One common question in relation to the COVID-19 pandemic is what impact it has on contractual relationships. People who entered into contracts prior to the virus's spread are now wondering if they can get out of those contracts, or if their clients can, as they're no longer economically viable or may simply be inconvenient at this time. In general, unless your contract allows you a specific right to terminate without cause, the only way you will be able to terminate the contract is if both parties agree. If one party refuses to agree to a termination, you will be bound to fulfill your obligations under the contract unless doing so is impossible, either permanently or temporarily. In the first case, if compliance is impossible permanently or indefinitely, and you will never be able to perform your obligations under the contract, it is deemed to be frustrated. When a contract is frustrated, it allows either party to be discharged of their obligations under the contract without penalty. Usually the losses will be shared amongst the parties in proportions that they agree to, or if they can't agree, as determined by a court. If compliance with a contract is impossible temporarily, you may be able to rely upon a force majeure clause in your contract. This is different to frustration, as it does not apply in every case. It will only be available if your contract has a force majeure clause within it. Force majeure clauses generally refer to things such as acts of God or actions which are outside of the control of either of the parties. If you have a force majeure clause, it will generally allow you the option to pause or suspend compliance with the contract. That pause or suspension will continue until the force majeure event is resolved. Some force majeure clauses will also allow for termination if the force majeure event persists for a certain period of time. In all cases, you should make sure you read your contract carefully so that you understand your rights under the force majeure clause. By way of an example, if a function centre had planned a wedding in a few weeks' time, it may well be that we currently have a force majeure event, at least until the government's limitation on gatherings is lifted. This is not, however, frustration, as after the limitations are lifted, the contract can be performed. And so unless the force majeure clause allows you to terminate, you will still be bound by the contract eventually. If we contrast that to a function where there is a specific once-in-a-lifetime event, that contract may be frustrated. If the function centre, for example, had a Halley's Comet watch party and it was not able to take place on the exact date required, it would not be possible for it to go ahead and the contract would be frustrated, allowing either party to terminate if they chose to. If you don't have a written contract and you don't have a force majeure clause, don't panic. It may be, depending upon the nature of your contract, you still have some options. Your contract may be a written contract, it may be terms and conditions on your website, emails exchanged between you and the other side, or even verbal discussions. In all cases, we strongly advise you to get legal advice. If we can help, you can find our contact details at wallmans.com.au.